The much-awaited High Court verdict on the hijab issue has finally come out. A massive setback here for hijab petitioners. Karnataka High Court has dismissed petitions challenging ban on hijab. The three-judge bench observed that wearing the hijab is not an essential religious practice in Islam. The bench in its verdict has said that the restriction on wearing uniform is a reasonable restriction that students cannot object to. Let's cut across. Yediyurappa speaking here on the issue of the hijab verdict.
Welcome the decision of the Honorable High Court of Karnataka on school uniform issue. The decision of the High Court has proved that the constitution of Supreme over the religion and his beliefs. I request public to honor the decision of Honorable Court and not to continue further in this issue.
So petitioners are saying that we'll go to Supreme Court and
let them go because the constitutional matter. Even Supreme Court, it will not help for them.
They are also saying
better to accept this decision and support, give all type of support.
So
to
they are
this.
also saying.
So you think there needs to be some amendment to the Education Act now, sir?
How can it be possible? Thank you.
Yediyurappa, their former Chief Minister of Karnataka, an integral part of the BJP in the state. Yediyurappa, hailing the Karnataka High Court's verdict, says that this must be followed, must be respected. Remember, the Karnataka High Court has very clearly stated the three-judge bench observed that hijab is not an essential religious practice in Islam. The bench in its verdict has said that the restriction on wearing uniform is a reasonable restriction that students cannot object to. The High Court has also said that it can't dismiss Karnataka government's order that's dated 5th of February, which mandated uniformity and banned any religious symbols. There was a lot of criticism that order was arbitrary, that it came about once the girls protested, that this did not have sanctity, etc. The High Court's verdict now almost squashing all that criticism, saying the Karnataka government coming out with a fresh order, reinforcing uniformity in these schools and colleges is not unconstitutional. This is what the High Court says, while also declaring that students cannot resist uniformity and that hijab itself is not an essential religious practice and that uniformity must be maintained. Let's have a listen at all those reactions coming in post the Karnataka High Court's verdict.
Three-bench High Court has given a verdict that the uniform order by the government has been upheld, and they have mentioned that hijab is not an essential practice of religion. Therefore, I request everybody in the society, in the parents, teachers, students, and those who are concerned about education to whatever the High Court has said, we have to see that it is implemented and peace and order is maintained.
Only in December we found, particularly by 6 students of Udpi, such confusions had been created. They were saying that we wanted to follow our religious practices. We tried to convince them. They were unable to be convinced and they went to the court. Actually, government did not go for the court. You should also know that. They prayed before the court that hijab is their religious practice and their constitutional right. And court has clarified it. It is not the essential religious practice. Second, according to the constitution, it is a restricted right, and both have been clarified, and there will be no confusion in future for any student. And again, through you, I request the student to follow the judgment of the court and come to the college and continue the education.
The court has held fundamentally that it's not an essential religious practice at all. So the question of public order.
Students are likely to move the Supreme Court now. How is the government prepared? Are you also preparing to contest that in the Supreme Court if it's appealed?
Most certainly, most certainly. We have raised substantial contentions before the High Court. If and when the matter is moved before the Supreme Court, we shall answer this.
Any likely to move a caveat or anything in Supreme
We
Court?
will have to decide in consultation with the government what is to be done. Thank you.
But you're happy with the verdict today, sir, because it was the longest of the longest hearings that...
Certainly, because apart whether it is for the state or against the state, it settles an important question of law raised and also the unseemingly avoidable controversy. I'll say that.
All right, India Today's largest team of reporters on ground have been right from day one, bringing us all the factual details, all sides and angles of this hijab controversy, completely unbiased. Nalini joins us from Delhi, who's been observing the court's verdict and those developments. Nolan Pinto, of course, in Udupi. Nagarjun also coming in from Bengaluru. Pramod Madhav is joining us from Shimoga. But let me start with Nalini and Nolan. Nalini, over to you first. The Karnataka High Court's verdict, many of them now, including those, of course, naturally those petitioners objecting to it, calling this an absolute violation of constitutional rights. The argument itself was whether or not hijab is an essential religious practice, to which the Karnataka High Court has said, no, it's not, and therefore follow uniformity, and that the Karnataka government's definition of uniformity cannot be vetoed. Elaborate to us what exactly this High Court's order says, which now can be almost a landmark decision and a reference point for every other state in the future.
See, Nabila, first and foremost, like you also pointed out, this is by no means the end of this matter. This matter will come to the Supreme Court, and there will be various observations made by the Supreme Court itself before it's decided in finality. So this is not the last we've heard from courts when it comes to this entire hijab row. But let me tell you why this entire order is so significant, and that's because this is the first judgment that is coming from this High Court on this issue that specifically states that wearing of a hijab is not a part of essential religious practice. So it is this judgment which has now become the yardstick through which the Supreme Court is going to decide further on this issue. So the petitioners will have to specifically point out flaws in this judgment to prove their case before the High Court. One. Second thing we have to remember is that this is a unanimous judgment. There were 3 judges on the bench, including one Muslim woman judge who has agreed with this sentiment that the petitioners, and in fact it is important that we read out what the order says here, is that the petitioners have miserably failed in making out the case that wearing of a hijab is even an inviolable practice. Forget talking about an essential religious practice. So that is what the Karnataka High Court has said, which is so significant in this matter, because that is what is at the crux of this entire issue as to whether or not these petitioners have a fundamental right to wear a hijab or not. The second most important thing that the Karnataka High Court has said through this judgment is the fact that the students cannot object to these restrictions that have been put in place by the college administration. There were a lot of concerns that were raised regarding the constitution of the College Development Committee itself, stating that it was headed by an MLA that was, of course, defined by his political leanings. So should politics be allowed to enter into the arena of education at all? But in that regard, the Karnataka High Court has clearly said that students cannot object to the restrictions that have been put in place, because these are a part of the reasonable restrictions that are allowed under the Constitution when it comes to in the interest of public health, morality or public order. So these are 2 significant takeaways that we get from this entire judgment. Now, as to what happens in Supreme Court, where there's a stay on it, that's of course what the petitioners will be pushing for. But we can be rest assured that it will take them a significant amount of time to go through this order, which runs into over 100 pages, and file a comprehensive appeal challenging it in the first place.
Right. You know, Nalini, I'm going to come back to you on the matters that the court has quashed the petitioners' every point. It almost seems like every point has been vetoed by the court, calling this not valid. Those points, if you can elaborate, right after Nolan bringing us more on that. Nolan, you have someone with you in Udupi, the district where we saw this situation escalate. We know that the situation right now may be tense, considering those petitioners hail from Udupi district itself. Who do you have with you?
Well, Nabila, in fact, we are outside the press club in Udupi, and we have with us Mr. Hussain, who's from the Muslim Organization Federation. He's in charge of the legal cell. I'm actually going to speak to him on this particular order, because apparently they're planning to actually take this up in the Supreme Court. Thank you for speaking to India Today. First of all, your comments on this particular order.
एक्चुअली ये जो ऑर्डर आया है हाई कोर्ट का, उसको हम लोग फुल रेस्पेक्ट करते हैं, सेम टाइम में हमें यहाँ के कॉन्स्टिट्यूशन में हमारा पूरा भरोसा है। उसी हिसाब से हम लोग कॉन्स्टिट्यूशन ने जो राइट दिया है, अगर हाई कोर्ट में अगर आपका जो राइट वो क्लेम नहीं हुआ तो सुप्रीम कोर्ट तक जा सकते हैं। इसी हिसाब से हम उसका राइट्स के हिसाब से ही हम लोग सुप्रीम कोर्ट में जाके हमारे जो कॉन्स्टिट्यूशन राइट है उसको हासिल करने के लिए हम लोग अपील फाइल कर रहे हैं बच्चों के थ्रू से।
Now, while you actually appeal in the Supreme Court, will the students get back to college? Because the Chief Minister, the Education Minister have actually stated that the uniform is about uniformity, that everyone is looked upon as equal in schools and colleges. So why don't they now come back to schools and colleges? Education is important.
Actually, ये आपने जो बताया, जो स्टूडेंट्स है वो उनको फुल इंडिपेंडेंट उनको राइट है, वो जा भी सकते हैं, नहीं भी जा सकते। अगर कोई ना जा सकता है उसको हम लोग कुछ नहीं कर सकते। हमारा ये रहेगा कि उनके लिए लीगल जो राइट्स है, कॉन्स्टिट्यूशन राइट्स है, वो दिलाने के लिए वो बच्चे जो हमारे साथ दे रहे हैं उनको ये कर रहे हैं, और उनको स्कूल को जाने का या कॉलेज को जाने का और उसको रोकने का बारे में हमारा कुछ भी इंटरफेयर नहीं है। उन्होंने फुल उनका आज़ादी है, वो जाके उधर एजुकेशन ले सकते हैं, एग्जाम को भी अटेंड कर सकते हैं। विद हिजाब वो जाना चाहते हैं, अगर विदाउट हिजाब भी अगर वो उनको जाने का है तो बहुत से बच्चे पढ़ रहे हैं। उनका इंडिविजुअल ये है, राइट है। हाँ, सुप्रीम कोर्ट को जो बच्चे हमारे साथ उनके लिए क्लेम के लिए हमारे साथ सपोर्ट करें वो लोग सुप्रीम कोर्ट को जाएंगे हम।
Thank you. Nabila, in fact, what Mr. Hussain from the legal cell over here from the Muslim Ukuta says that they're not going to stop students who want to go without a hijab. They're not going to say that. They said that the ones who want to do that can go ahead. The ones who don't want to do that can also go ahead. But they, on behalf of the students, are now, because they say that they do have the constitutional right to take this matter up to the Supreme Court, and they will do that to fight for the rights of these students.
Right. You know, Nolan, many of those colleges in Udupi, Kundapura area, that's the area, the coastal belt where we saw protests that erupted. After one college, it almost escalated to all those neighboring colleges. Many of those colleges were allowing hijab in the past. Will this verdict by the Karnataka High Court really alter that decision, which we already saw commotion right after the interim verdict was out? Any word from the college management or institutions that now that they're going to roll back on what was being allowed in the past post this verdict?
Nabila, there's been a lot of discrepancies when it comes to this particular issue, because, like you rightly stated, many colleges didn't allow students to wear their hijab inside, and some other colleges did allow. Now, the High Court very clearly states that, one, that wearing a hijab is not part of essential religious practice in Islam. It also says that the government has the right to prescribe uniform, and it also upheld the right of the CDC or the College Development Committee to prescribe the type of uniform they want to. So in effect, it says that if the CDC of that particular individual college does allow a student to wear a hijab, they'll be able to actually wear inside. But if the CDC does not allow them to do so, the students, like at the Udupi Women's College, will not be able to go to the High Court and file a case saying that my rights are being taken away. It's part of my religion, essential religious practice. They won't be able to do that because the High Court has very clearly now stated that the CDC can prescribe a uniform, and that is proper.
All right. Thank you very much, Nolan. I'm going to come back to you. This is, of course, a developing story. This does not end here. Like Nalini rightly said, the matter is going to be escalated, and this is what we hear from the Council of those petitioners as well. They're going to take this matter to the Supreme Court. But I request both of you to please stay with us. I have some updates coming in, reactions on this hijab verdict. Saduddin Owaisi now, who's been arguing for hijab to be allowed even inside classrooms, has now reacted on the hijab verdict. Owaisi tweets, and I quote, "I disagree with the Karnataka High Court's judgment on hijab. It's my right to disagree with the judgment, and I hope that petitioners appeal before the Supreme Court preamble to the Constitution says that one has liberty of thought, expression, belief, faith, and worship. If it is my belief and faith that covering my head is essential, then I have the right to express it as I deem fit. For a devout Muslim, hijab is also an act of worship. It's time to review the essential religious practice test. For a devout person, everything is essential, and for an atheist, nothing is essential. I hope this judgment will not be used to legitimize harassment of hijab-wearing women. one can only hope and eventually be disappointed when this starts happening to hijab-wearing women in banks, at hospitals, at public transport, etc. These are words from Asaduddin Owaisi's tweets that I'm quoting for you. Asaduddin Owaisi has extensively, even in the poll-bound state of Uttar Pradesh, raised the issue of hijab and the ban issued by the Karnataka government and educational institutions. He now elaborates on what the High Court's verdict says, almost saying that this is disappointing and he does not agree with the High Court's judgment. In fact, Owaisi says, it's my right to disagree with the judgment of the Karnataka High Court, and I hope that petitioners appeal before the Supreme Court. Preamble to the Constitution says that one has the liberty of thought, of expression, of belief, faith and worship. If it is my belief and faith that covering my head is essential, then I have the right to express it as I deem fit. For a devout Muslim woman, hijab is also an act of worship. It's time to review the essential religious practice test. For a devout person, everything is essential, and for an atheist, nothing is essential. I hope this judgment will not be used to legitimize harassment of hijab-wearing women. One can only hope and eventually be disappointed when this starts happening to women wearing hijab in banks, hospitals, public transport, etc. All right, here is Asaduddin Owaisi commenting on the hijab verdict. Now, the Karnataka High Court's order on hijab has really ignited a big political face-off as expected. While the Karnataka government and the BJP has hailed the order that's upheld the hijab ban, the likes of Asaduddin Owaisi, Mehbooba Mufti, Omar Abdullah have expressed disappointment over the court's order. PDP chief Mehbooba Mufti, who's been backing the petitioners through this entire hijab stir, said that women have been denied the right to choose, to choice, and this entire fight wasn't about religion at all. AIMIM chief Asaduddin Owaisi, meanwhile, has said that High Court's order suspends fundamental rights of women. Omar Abdullah echoed a similar sentiment, saying that the court did not uphold basic rights of women's choice of how she wants to be dressed. It's up to her. He went on to refer to the High Court order as travesty.
It is a very important step towards strengthening the educational opportunities and rights of girl children, especially those belonging to the Muslim community. A section of the society was trying to deprive Muslim girls from embracing education and modernity. This step, this judgment of the High Court, however, is going to further strengthen the opportunities, rights of the girl children to access education.
मैं इतना ही निवेदन करता हूं, छात्र का एक ही उद्देश्य रहना चाहिए, पर्पस रहना चाहिए, एम रहना चाहिए कि ज्ञानार्जन करना। अभी आप ज्ञान के लिए जा रहे हैं, ये सब बंद करिए, किसी में इसमें ज़्यादा पॉलिटिकल स्टेटमेंट मत कराइए, कृपया जाके कॉलेज या स्कूल में पढ़िए और ये सब जो कुछ भी हुआ है वो भूल के सब भाईचारा दिखाते हुए काम अपने कॉलेज में, अपने स्कूल में पढ़ाई करिए। इतने मैं निवेदन करता हूँ। इसमें फिर से, क्योंकि अभी न्यायालय ने निर्णय दे दिया है, सबको मानना पड़ेगा। ये तो हमारा, इसमें तो कोई और कोई ऑप्शन भी नहीं है। इट इज ए मैंडेटरी दैट एवरीबडी शुड फॉलो इट। इतना ही मैं निवेदन करता हूँ। इसमें ज्यादा पॉलिटिक्स न करते हुए सब इसका स्वागत करें और इसके पालन करें।
हिजाब को लेकर हारा हंगामा एक साजिश और षड्यंत्र के तहत किया गया था ताकि मुस्लिम लड़कियां फॉर्मल एजुकेशनल इंस्टीट्यूशन से बाहर फेंकी जा सकें और ऐसी तालिबानी सोच वाले संस्थानों में जा सकें और उनमें दाखिला करा सकें। ये एक षड्यंत्र है जो अपने आप में टाइटा फिट हुआ है।
कर्नाटका हाईकोर्ट का फैसला कर्नाटका सरकार की बातों पर मुहर लगाता है। ये जीत है उन लोगों की जो संविधान को शरिया के ऊपर रखते हैं। ये जीत है उन लोगों की जो किताब को हिजाब के ऊपर और हिजाब से ज्यादा अहमियत देते हैं शिक्षा को और महिला सशक्तिकरण को अहमियत देते हैं, ना कि वोट बैंक पॉलिटिक्स को। ये करारा तमाचा है उन पार्टियों के चेहरे पर जो बार बार महिला सशक्तिकरण की वैसे खोखली बातें करती हैं, लड़की हूं लड़ सकती हूं के नारे देती हैं, पर बार बार शाह बानू से लेकर शायरा बानू तक या हिजाब के मामले में बार बार महिला अधिकारों का गला घोटकर कट्टरपंथियों के साथ वोट बैंक के चक्कर में खड़ी हो जाती है। आज ये भी साबित हो चुका है कि हिजाब केवल एक बहाना था, वोट बैंक को भड़काना था, क्योंकि यूपी चुनाव पर निशाना था।
मैं शुरू से जो आज कर्नाटका हाईकोर्ट ने अपहोल्ड किया है, मैंने शुरू से यही बात रखी थी कि जो पूरा मुद्दा था वो रूल्स एंड रेगुलेशंस का मुद्दा था, वो रिलीजियस इशू नहीं था। उसको रिलीजियस इशू बनाया गया, पॉलिटिकल इशू बनाया गया, जो बहुत ही दुर्भाग्यपूर्ण है। और ये जब अब बात आई है, अब कर्नाटका हाईकोर्ट ने वही डिसीजन लिया है जैसे महाराष्ट्र हाईकोर्ट पहले ले चुकी है, केरला हाईकोर्ट ले चुकी है। अब इसका सभी सम्मान करेंगे और उस पर राजनीति खत्म करेंगे।
According to me, whatever argument advanced by the petitioners is correct. But court has taken a decision. We have to go by the decision of the High Court.
हिजाब के बारे में कोर्ट क्या डिसीजन लिया है, मैं बहुत संतोष से उसको स्वागत कर रहा हूँ, क्योंकि बहुत दिन कर्नाटक के मुसलमान वो विद्यार्थिनियों को बहुत प्रॉब्लम हुआ था। कोई आदमी उनको प्रचोदन दिया था, इसलिए ये प्रॉब्लम था। लेकिन आज कोर्ट क्या डिसीजन लिया है, उसको कौन कौन प्रचोदन दिया था, वो पहले उनका क्या करना है वो डिसीजन लेना है।
कोई आदमी माने कौन है सर?
हाँ,
कोई आदमी माने कौन है वो
मुझे मालूम नहीं। इसलिए सभी विद्यार्थिनियों को अच्छा शिक्षण देना है, इसलिए कोर्ट क्या बोला है वो सभी भी उसका मानना है।
All right. The Karnataka High Court's verdict now establishes a couple of points. I'm going to reiterate those points right here. Will hijab students be instigated to boycott campus and classes? Now, these are questions that we ask as it might prompt reactions from different parts of Karnataka. We already saw stiff resistance on the Karnataka government's order. And now with the High Court's verdict almost establishing that the colleges can decide uniformity, it now appears that situation might escalate to proportions that we do not want to see. Will the verdict camp resentment or really amplify this campus anger? That's the question that we want to see as it unfolds. Will this verdict spark a law and order situation courtesy fringe groups? We saw several groups, several fringe elements on both ends protesting vehemently, saying that their religious symbol must be allowed. Will this really escalate the matter further? After appeal, could the Supreme Court take a different view? Will, of course, the Supreme Court take up the matter in the first place? And once it does, will there be further deliberation on whether, again, another round of argument that they will hear on whether this is an essential religious practice, or will there be a whole different view to this debate? Has the High Court won public faith and confidence with this verdict? That's the question that needs to be asked. Of course, those who are opposing the High Court's verdict will say that this is a violation of their fundamental right. And those hailing the High Court verdict, of course, looking at this as an absolute victory to, of course, the decision taken by the Karnataka government when it comes to uniformity. And there is a large view from large sections of the society that believe very strongly that in educational institutions, uniformity must be maintained. Wear your religion outside all you want, but inside classrooms, try and maintain uniformity, because this is the decision taken by those educational institutions that want to see students all in one, not viewing them as one from a different religion or one from a particular religion. At least that's the sense they do not want to instill among the students studying in their institutions. Nalini joining us, giving us a court perspective. Nalini, again, I'd like to ask you, these petitioners have time and again said, right after the verdict came out, it's been close to 2 hours now, here the petitioners condemning the High Court verdict, saying that this is an absolute violation of our fundamental right. This is a violation of the Constitution, and this verdict will be challenged in the Supreme Court. While they say that, what is your views of this large objection coming in from the pro-hijab community on this verdict?
Well, Nabila, although the petitioners might have full intention to challenge this verdict before the Supreme Court, as is their right, but until and unless there is a contrary order from the Supreme Court, it is this order of the Karnataka High Court that will essentially stand, at least when it comes to legal precedent. So this will be this order that will be enforced. Now, the problem with orders from the court when it comes to matters of faith is that courts often pass orders, but implementing them on the ground is a completely different ballgame altogether. If you remember, when the Supreme Court had passed the judgment in the Sabrimala case, where they had said that women should be allowed to enter the Sabrimala temple, there was a large amount of resistance that we'd seen on the ground, where the order of the Supreme Court, despite that it came from the highest court of the country, was not be able to implement for a significant period of time even after the order had come. So it is difficult to implement orders on religious aspects, even though they come from court, because a simple piece of paper is something that does not change the mindset of the people who follow these practices and believe in it with all of their faith for a really long time. So it's a change of mindset that's required. At the same time, the Karnataka High Court, right at the beginning, when they were speaking about this judgment that they'd passed, they said that they'd taken a holistic view of things, and on the basis of that, they'd passed this judgment. But even though they've taken a holistic view of things, we need to remember that they've taken a holistic view only of the preliminary issues that were before them right now. There were a lot of subtexts and sub-issues, as there always are when it comes to legal cases, that the Karnataka High Court actually refused to get into, saying that that is not the question that is before the court. For example, even if the Karnataka High Court had held that wearing of a hijab was an essential religious practice, the question that was then before the court could become as to whether or not the government, with the reasonable restrictions that they have under the constitution, can interfere in the issue of essential religious practices or not. So all of these issues the Karnataka High Court has not gone into at all while deciding their judgment, which the Supreme Court is likely to delve into because it is the highest constitutional court of the country, while deciding the issue in a larger perspective. So a lot of those subtexts will also come into play when the matter comes before the Supreme Court. But like you correctly pointed out, the main question today is as to whether or not this Karnataka High Court order that is currently in force will be allowed to be implemented on the ground, and whether people will follow it or not. Because when the interim order had come on similar lines, the students flat out had refused that they are not going to enter colleges without a hijab.
Well, we know that there's been large-scale objection even to the interim order, and that interim order also led to a lot of confusion among institutions that earlier allowed it. So this verdict, of course, will prompt some kind of protest. That's what's expected. But so far, I think Karnataka has done a fabulous job in ensuring law and order. The Karnataka government has deployed large deployment of police in different areas that are currently volatile and sensitive. So far, we haven't heard of any instances of protests, and this is slightly satisfying to know that people largely have maybe adhered to what the High Court has said. The petitioners, of course, naturally are upset. They want to reach out to the Supreme Court, but we haven't seen any kind of volatile protests or objection that's come out on a large scale. But we're going to continue keeping the spotlight on this story.